Judgment in the appeal Roberts against Gill Co Solicitors and others.
The judgment of the court will be given by Lord Walker.
The unusual facts of this case have given rise to some technical and difficult questions of law. The full facts have not yet been established at trial, and as a result of this court's decision, there probably never will be a trial. A brief summary of the undisputed facts is sufficient. Mrs. Alice Roberts died in 1995. Her grandsons John and Mark were beneficiaries under her will. John was entitled to a valuable farm on condition that he paid all the inheritance tax on the estate. The executors renounced probate. John obtained letters of administration in 1996, and in 1997 he proceeded to sell the farm for his own benefit, despite the fact that about £60,000 in inheritance tax remained unpaid. It is still unpaid and amounts with interest to over £100,000. Two firms of solicitors, the respondents to the appeal, were instructed by John at different times during these events. In 2000, another solicitor, Mr. Sainter, was appointed as administrator in place of John. In 2002, John's brother, Mr. Mark Roberts, whom I'll call the appellant, sued the two respondent firms of solicitors for breach of a duty of care said to have been owed to him as a beneficiary under Mrs. Roberts' will. The more natural claim would have been a claim by Mr. Sainter as Mrs. Roberts' personal representative on behalf of the estate. But Mr. Sainter was not made a party, although his firm had been acting for the appellant since 2002 at latest. Any claim by the personal representative arising out of the sale of the farm would have been statute barred by 2003 at latest. In 2006, the appellant asked for permission to amend his pleadings in two respects. First, to describe himself as suing both on his own behalf and on behalf of the estate, and second, to allege breaches of duty owed to the estate. There was still no application to join Mr. Sainter as a party. Instead, the appellant wished, as a beneficiary, to bring a derivative claim on behalf of the estate, as well as suing on his own behalf. The deputy judge refused permission to amend on the ground that special circumstances are needed to justify a derivative action, and they had not been established. The Court of Appeal, by a majority, held that there would have been special circumstances, but unanimously that the administrator would have had to be joined as a party, and that Rule 19, paragraph 5 of the Civil Procedure Rules did not permit this once the limitation period had expired. The Supreme Court holds unanimously, the leading judgment being that of Lord Collins, who cannot be here today, that special circumstances had to be shown and had not been shown. A majority of the court also takes the view that the Court of Appeal was correct in its decision as to the need to join the administrator and its consequences under the Civil Procedure Rules. The decision of the Court of Appeal is therefore affirmed on different grounds. The appeal must be dismissed.
The court will now adjourn.